Yes, Your Honor. 6 minutes, please.
Very good, sir. And you know how the light system works. You may proceed.
Yes. May it please the court. This brief includes 6 issues, 4 of which relate to the statement, to a statement made by a co-defendant that the defendant alleges was in violation of Bruton or in the alternative impeachment. Another issue involved the introduction of, or the court's refusal to allow the introduction of gunshot residue, the results of a gunshot residue test, and the third issue being the court's decision to allow phone records that purportedly attributed my client to the phone records. The first thing I want to talk about in the impeachment issue, the state did file a notice of supplemental authority. And what's really important in that case, and I know the big issue in the impeachment issue was the Callaway case. And in the Callaway case, the court did find that the impeachment was admissible. However, there is a key distinguishing component in the Callaway case that makes this case distinguishable from the Hall case, which I cited throughout my initial brief. The Callaway case specifically dealt with the testimony of an expert witness and went to his credibility as to whether or not a confession was falsely admitted into evidence, or excuse me, whether a confession was involuntarily given to the court. In that case, the court specifically held that because the information in that particular case was admitted into evidence, and the 2 statements were specifically used for impeachment purposes, that was okay. That is not what happened in this case. In this particular case, the court allowed the following statement into evidence. They came and picked me up. However, that particular statement went unattacked by the defendant, and he was unable to ascertain the truth or falsity of the statement. For this reason, our argument was that the statement was improperly admitted into evidence. Most importantly, what the court should look at is the fact that when the statement was given, although the state said it was for impeachment purposes, the court, there was an inability to ascertain the truth or falsity of the statement. With that said, the big problem in that case is the state used that throughout its closing argument. The state said, because this statement isn't true, none of the other statements are true. Remember, Ebony Jackson testified that the co-defendant and the defendant, Byrd, were at their house. So with that said, what happened in that particular case was the jury had to pick between a statement that was tested, the testimony which was given to by Ebony Jackson, and the statement that went untested, which was given by the co-defendant in the case, which would...
Well, it sounds like the defense is trying to have its cake and eat it too, because you're putting on the alibi testimony from Miss Jackson.
Correct.
Which prompts the state to say, well, if you do that, then we think you're opening door to impeachment. So the defense is on notice, and if the defense arguments prevails, they shouldn't have been able to admit it. They get to bring in this alibi witness and have no impeachment.
Well, I agree to the extent in Thomas Byrd's case, yes, because Thomas Byrd did not give a statement. But since the co-defendant in the case gave a statement, Kevin Samuel, that would be used for impeachment purposes. And the important part to note is in the state's brief, they specifically stated that the co-defendant's statement was admissible as impeachment under 90.608.5. Under 90.608.5, the admission of impeachment testimony is only admissible if it's proof by other witnesses. That's the first part, and that's what's problematic. And again, I'm using the state's own argument here. The state says this statement is admissible as proof by other witnesses, that the witness testifying is proof by other witnesses that the facts are not as testified to by the witness currently testifying. Here's the problem with that. That specific statement was given by a witness who did not testify. So the answer to your question is, no, No, it's not trying to have their cake and eat it too. It's actually the state's attempt to have their cake and eat it too. And that now that they would not be able to admit this statement into evidence in Byrd's case, they're using a statement that would be admissible in Samuel's case because it was his inconsistent statement against Byrd in this case. And what's important is the statement on its face, just looking at the statement itself, they picked me up, specifically implicates or implicates by inference Thomas Byrd's involvement in the case. I say that because they came and picked me up means it was sometime after the murder that he was picked up. So under those circumstances, the statement was standing alone and untested, and that's what's key, and that's what Hall talked about too. The Hall case, I did cite to that almost ad nauseum, but the reason why I did that is simple. That statement went untested. So what happened is it was unable to see, the jury was unable to hear or look at the credibility of the person who gave that statement. If you think about it, had that statement not come in, all the jury would have heard was Miss Jackson's testimony, which was they were with her at the time.
Well, the jury also heard evidence from another eyewitness who saw two of the individuals going into the van and the van taking off, suggesting that there were three people in the van.
Well, yes, and the defense did try to argue that it was possible that there were. Well, the answer to that is yes, you're correct. But we also know that two of the people who were charged in this case were Sherman Colson and Kevin Samuel. And the reason why that's important, and it somewhat indirectly relates to the admission of the gunshot residue testing, is had that been admitted into evidence, one of the things that the state, one of the components of the case would have been, one, Colson was the shooter, two, either Samuel was in the car or Samuel was one of the people running. And that would have linked those two, or at the very least that was Thomas Byrd's defense, but he was unable to make that argument anymore once that statement came in, or excuse me, that argument basically went unanswered to because of it.
What about applying the harmless standard, the harmless error standard, assuming that what you're saying is true and this was error? How do you survive a harmless error?
Simple. Oh, I'm sorry.
Go ahead.
The answer is very simple. There were no one identified Sherman Colson, no one identified Thomas Byrd, and no one identified Kevin Samuel as the shooter or the people running. Admittedly, they saw three individuals. Two of them were running, and one of them, I guess, get tackled. But no one, in fact, I don't even believe anyone identified the victim. And what I mean, and let me clarify that by saying, no one gave a description of that matched Thomas Byrd. None of them gave a description that matched Kevin Samuel.
Well, they matched the vehicle up, right?
Agreed. Well, even if there was some dispute.
They found the victim's cell phone.
Yes, but they did not find yes, they did, but they did not find it on the person of Thomas Byrd. And what makes this different than Colson, and what makes this different from Samuel, is that the defendant actually fled from police before the car was stopped. Now, certainly, of course, that's a double-edged sword, but at the very least, the argument can be made in good faith that the phone was not found on on Byrd's person at the time. So, and that was. And in terms of the harmless error, the answer to your question is because of all that, when coupled with the gunshot residue that would have pointed towards Colson being the shooter, and with the fact that the cell phone records, the key to this case would have been the records that the state was allowed to introduce concerning Byrd and the name with the records, and that's the biggest problem where the confusion. That was one of the issues that I addressed in my brief. In that case, the only evidence or the only argument, and this was the state at the trial level's position, was all we have is argument. I think they said that too. Your Honor, this is only argument. But our argument is that the phone was lost in the struggle. Even if there was a struggle, it should be noted that the police canvassed that area for a great length of time and no phone was ever recovered. And that was another issue in the case, in that yes, the phone was registered to a Jason Byrd, but the defendant never went by the name, never used the name Jason. In fact, what would point to the phone not being his is also the fact that he does go by a different name, which I believe it was Mikey. And even then, the phone wasn't registered in his name there.
Wasn't the phone, the bill assigned to the girlfriend's address?
Yes, but not Thomas Byrd's girlfriend's address. It was Kevin Samuel's girlfriend.
So is this a coincidence that the last name Byrd just happened to show up on the bill?
Coincidence? No, but it has to be taken in context. Coincidence that the name was chosen? No. Because again, the position would be that it was actually because Kevin Samuel and Thomas Byrd were half brothers. So no, it wouldn't be a coincidence or out of the question for the jury to believe that that phone was used or that phone belonged to Kevin Samuel and that the name Byrd came from a name chosen by Kevin Samuel. But in terms of it actually being a coincidence as it applies to Thomas Byrd, I think the good faith argument is yes, it was, well, I don't want to call it coincidence, maybe serendipitous or an anti-serendipitous connection. And that was key in this case too, which again, it should concern the court that the phone belonged to somebody. And that's where the prejudice came in. It either belonged to, it belonged to somebody, and it also basically improperly rebutted the defendant's alibi that they weren't there.
But it sounds like you're arguing that the state had to prove with certainty that it belonged to your client as opposed to putting forth circumstantial evidence that it could be your client's.
Certainty, no, but with the probative value that would not be substantially outweighed by its prejudicial effect, which I did argue in my brief, yes. Meaning, if it's more likely than not, especially just looking on the face of the record, it was more likely than not that the phone belonged to Thomas, or to Samuel, to Kevin Samuel. I say that because, again, the phone was registered to his girlfriend's address. He used a name that was similar to that of his half-brother, the exact same name as his half-brother. Those two components would certainly be more likely that the phone belonged to him than it would be to Thomas Byrd. And not only that, it would have helped out indirectly the alibi defense, at least in terms of Thomas Byrd not being there at the time of the offense. So with that said, that also goes into the gunshot residue test, which I think is out of all the issues is perhaps the most concerning for this reason. When the defense argued for the admission of the Garland, the admission of the gunshot residue test, they had before them the Garland case. And the Garland case specifically authorized the admission of these gunshot residue tests. It was undisputed at the time that they were admissible. Not only that, it was completely an admission by a party opponent. And there was the case law that I provided to the court that said that these are admissions by a party opponent, and yet it was still not, the court refused to allow this.
But you didn't argue party opponent admission at trial, did you?
No, they did. I'm not trying to read your mind, but I think the reason why you say that is in the answer brief, that's what the state said. But no, in my reply brief, I specifically pointed out with specificity the part in the transcript where they argued it was an admission by a party opponent. That's one. Two, the Garland case, which they did provide to the court, specifically said it was admissible as an admission by a party opponent. And more importantly, the red herring in this case is the idea of the need for an expert. There was nothing in the Garland case that said you needed an expert witness to admit these records into evidence. What the Garland case simply said was that it was an admission by a party opponent, and therefore it was admissible. You just needed some indicia.
Well, don't you have to authenticate the document? And wouldn't the authentication possibly require, or probably require, someone who's able to interpret the document?
Yes, and the defense did have the defense had CSI Thomason, and CSI Thomason, and admittedly CSI Thomason said she was not an expert, but the counter to that is my client said he was innocent, and look what happened. Meaning, just because someone, and I know this is going to sound strange when I say it, but you'll understand it shortly, is just because a person says they're not an expert in something doesn't necessarily mean they're not an expert in the something they're saying they're not an expert in.
But isn't that a discretionary call by the trial judge?
It is, but in this case it was. But again, applying the Garland case, because the court had the benefit of the Garland case, the question then becomes, right, an abuse of discretion is whether out of 10 judges, whether one would find that Garland didn't apply to the facts in this case. And quite frankly, in this case, it was an abuse of discretion because it was an admission by a party opponent. And more importantly, Thomason said, she specifically said, she's done this test, I believe it was 12 different times. Now, she wasn't aware of, admittedly, she said she didn't think it was good any longer or that they stopped using it, but they still used the test nonetheless, and that would have gone to weight and not admissibility. And what was important in the Garland case is, again, it was trace amounts of gunshot residue. It was something as little as trace amounts. So in that particular instance, this was, whether she thought she was an expert or not, was something that could be brought out in cross with the state. And it also begs somewhat of a unique question because in Florida, the jury never hears whether a person is an expert or not. It's in federal court. They say at this time we now tender this witness as an expert. So in terms of the jury knowing whether or not this was expert testimony, that too would have been an issue.
So let's say hypothetically we were to reverse on the first issue and therefore we don't reach this issue. On a retrial, I'm presuming that because the state, once they heard their own witness mention the GSR test, all of a sudden said, stop, we want to voir dire our own witness to keep her from testifying any further on this issue. I would expect on a retrial the state's not going to be seeking to offer that evidence, or at least better caution their witness, don't mention gunshot residue test. Is the defense going to be seeking to introduce this evidence given the evolution of the case law since Garland?
Well, let me start with the last part of your question. From what I understand, if the court can clarify by evolution, are you speaking in terms of the Fry v. Dahlberg standard?
Correct.
The honest answer to that question is I don't know. I assume because it's evidence, since we're speaking of a hypothetical, if it was me and I was the trial court attorney, I absolutely would do everything I could to admit this into evidence. It should be noted that neither party submitted any evidence that the gunshot residue testing was no longer reliable. That's an important part. Again, what we heard was argument, and I did put this in my brief that what attorneys say is not argument, and that the court should, one of the things that this court has said time and time again in the practice they'd like to see stop is for attorneys using argument as fact. So what we do know, what's undisputed, is at the time this case happened, gunshot residue tests were admissible. They were also admissible as a party opponent. In terms of admitting them, the answer to your question is yes. If they under the Fry or the Dahlberg standard, would there need to be a hearing? Well, that again would be on the state, I believe, if they're seeking to question the admissibility. But yes, I would think it would behoove the defense to put in that evidence, coupled with the fact that if the court were to also find that the record should have been excluded, at the end of the day, what you have is a trial of witnesses who never saw the defendant. If the court keeps the phone records out, there's nothing that the state cannot argue that a phone was near the scene or that Byrd's phone was near the scene of the crime, and they're just left to either accept the alibi statement as is or the circumstantial evidence of Thomas, or the state's witnesses suggesting that Thomas Byrd was one of, well, that's the other problem, suggesting
You're well into your rebuttal time.
Okay, well,
I'll give you
No,
a couple of minutes.
no, Your Honor, I'm actually, at this time, I'm going to reserve the rest of the time and maybe even less.
Okay, thank you.
May it please the court. Georgina Jimenez Orosa, Assistant Attorney General on behalf of the state. As to issue 1 through 4, I believe that Callaway is totally controlling in this case. In Callaway, it was a non-testifying witness as well. And the court specifically said that a co-defendant's incriminating statements are admitted for non-hearsay purposes, such as impeachment, do not invoke the protection of the Confrontation Clause. Here, the state never used Samuel's statement, which were not confessions. He never confessed to being a participant in this case. The statement was redacted, and then it was admitted exclusively to impeach the alibi defense. They were tried in a joint trial, and this statement, so therefore Callaway is totally controlling on this issue.
Which provision of 90.608 do you think this statement by Mr. Samil falls under to be allowed even into evidence as impeachment?
Your Honor, admission, but in the testimony, maybe I shouldn't have used it. It's under admissions. They were tried together. However, the state never introduced that as an admission or or to prove the evidence of guilt of Mr. Byrd.
Admission is a hearsay exception. I'm not talking about the hearsay rule. I'm talking
sorry.
about 90.608, which gives 5 options by which you can impeach somebody. Number 1, introducing the statements of that witness, which are inconsistent. That doesn't apply. 2, showing the witness's bias. That doesn't apply. 3, attacking the character of the witness. That doesn't apply. 4, showing a defect of capacity, ability, or opportunity or of the witness to observe, remember, recount. That doesn't apply. 5, proof by other witnesses that material facts are not as testified to by the witness being impeached. As Mr. Noble pointed out in his brief and again today, proof by other witnesses. Mr. Samil was not an other witness. He did not testify.
He did not testify, Your Honor. However, his statement that he was a party opponent in this case, and so therefore, as under the admission, it would be admissible to impeach his alibi witness under his statement. And those 2 statements are totally inconsistent. And as the Supreme Court stated in Callaway, a non-testifying defendant's statement was acceptable as impeachment in this case, in Callaway, just as it was in this case. Be that as it may, even if you were to find that was improper, this was so harmless. As you will recall, there was an eyewitness that saw 2 men chasing the victim. She saw the van waiting for them. And then after the victim was shot and on the ground, they ran away, jumped into the van. The van was caught 11 minutes after. And upon being stopped, Mr. Byrd ran from the van. They admitted that they were in the vicinity because the aunt, the alibi witness, said she lived in the same area, several blocks up. So there is that they impeached her with this single line, they picked me up. The alibi testimony was even incredible. So even without that,
How so?
she said that she and her The three co-defendants had been drinking from 8 o'clock till 11:45. At 11:45, they ran out of drugs and alcohol, so they went looking for alcohol, couldn't find. So Colson, on his own, decided to go get, she gave him $40 to go get alcohol for them. And her two nephews stayed with her. Therefore, he left, Colson left in the van, which was Samuel's van, and he took too long. And she's wondering what happened to him. Right after the murder, he comes back driving the van, tells the two defendants, get in the car. And she says, what happened? Why took you so long? He gave her $20 back from her $20, and they took off. She didn't know anything. She didn't know what happened or why he was running. Then the chase happens. Byrd runs away after they stopped. And she, even though she finds out the next day that her two nephews, dear nephews, have been arrested for the murder, she disappears herself. She goes away, and 2 years later, just before trial, she comes back and says, yeah, they were with me. They were with me. Colson must have been the one. So the alibi defense itself was totally, the jury would not have believed. They caught the three of them in this van 11 minutes after from a chase.
All three of them weren't in the van.
All three were in the van, Your Honor. All three in the van, they were in the van. When the van stopped, Byrd ran.
Okay.
And was found, the stop occurred at 12:53. He was caught at 1:06 that same night, so within 10 minutes.
But it seems that the state shifted its use of Mr. Samil's statement from one of impeachment to one of substantive merit, because during closing, he's arguing to the jury, they did this, they did that. In other words, to implicate that Samil all of a sudden was picked up by Colson and Byrd and therefore was implicated in the murder.
Your Honor, I believe if you read the closing arguments, when the prosecutor again refers to this day, is attacking the alibi defense. The alibi defense. And if they ever said they, it was because the state said the three of them committed this murder.
Yeah, but logic would suggest that if you're attacking the alibi defense, you're saying there is no alibi, he did it. He was there. So that's arguing the truth of the matter.
Your Honor, the state never introduced this statement during its case in chief. It was not a confession. We did not want to use it. And so they were exclusively using it to impeach. And the theory, the testimony, the evidence all supports that the three of them committed this offense. Her testimony was that they were with me, that both of them were with me. Yet Samuel is saying, they picked me up. But we did not use that to support or to go against Byrd. Samuel, they both stood together. They both tried to use this one single alibi. They were half brothers. So they had a congruent defense and an alibi, and the state was saying you can't have one story or the other story. Those stories are just not consistent. And he wasn't using it to say, I didn't do it, he did it. That's not the way that, and that's the only way that that statement was used. I believe, the state believes that Callaway controls this issue.
Well, in Callaway, wasn't ultimately the impeachment of the sociologist based on his own notes, as opposed, in other words, he comes into court and says one thing, and then they show him his notes, which say something else. That was the ultimate impeachment. The co-defendant's statement within his notes was, for lack of a better term, dicta. That's the impeachment is his own notes against his statement in court.
However, it's you because of what he said about the non-testifying witness, as well as here, the non-testifying witness. So the state position is that it is controlling and that they are the same and exclusively used for impeachment purposes. And beyond that, even if it were, there is, I mean, it was harmless. It was so harmless beyond a reasonable doubt that it could not have affected the jury verdict in this case. Because, like I said, I do not believe that the jury would have believed her. She was impeached every other way by the fact that she stayed away for 2 years and only gave a deposition a month before trial and came and said, yes, I did this. They were with me. So that therefore, even the fact that she lived nearby, that they would, running from that Colson, running from just committing a murder, would go stop by her house down the street, pick them up, and then go up to Atlantic. It was just not credible and not supportable, and it went against all the evidence that Ms. Kelly gave, that she saw 2 people running into the van, and who are the 2 people that are in that van when it's caught is these 2 defendants. With reference to the cell phone records, all they did was evidence of this, where they were pinging from. So, like I said, it was within the area. They did not say, yes, the cell phone was at this location versus that location. It was just the area. Therefore, the state, again, asserts that if it was there in admitting these records, it was harmless beyond a reasonable doubt. It was just circumstantial evidence that showed that perhaps these were Byrd's records, but they did not prove anything. As far as the FDLE report, even in Garland, Garland said, before admitting this type of evidence, a trial court must first determine that there is sufficient independent indicia of reliability to justify admitting it. Here, the state was calling into question the reliability of the gunshot residue evidence from the beginning. The state told, we are not going to use that. We don't intend to use that. If they had intended to use it, they should have told us so that we could have a Daubert hearing.
So this witness who mentioned it was a state witness. She mentioned the gunshot residue test in response to a state question on direct.
Yes, Your Honor. However, all she said was, I did GSR swabs. She did not say she tested it or did it or sent it out. I was instructed by the lead detective to take the swabs.
Yeah, but I'm not suggesting there was any intent to drop this gunshot residue swab test before the jury and then go up to the judge and say, oh, Judge, we don't want to take this any further. Because we all know what the result was. It was negative for the defendant in this case.
Absolutely, yes.
So-
Well, okay, what Ms. Thompson testified to was she did a preview on Colson alone. Then she said, oh, if I keep doing this, I'm
I
going
should say it was positive on Colson, so I should have said.
She said, I did the test, the preview blue or something like that kit, and she noticed that there was a blue dot. From her knowledge, a blue dot means there is GSR. However, she says that test is like is a presumptive, like they do field test. Then the evidence gets sent to the lab.
I'm sorry if I'm not making myself clear. My point is, the state has, at this moment, the ability to control whether their own witness mentions GSR or not. She blurts it out. And the defense is sitting there saying, oh, Judge, she just opened the door. And although she hasn't testified to what the results were, what it means, she put it out there along with all the other tests that are done, leaving the jury with a suggestion or the implication that maybe this came back positive against the defendant, or negative is the term, maybe bad for him.
I do not, I would take issue with that, Your Honor, because all she said was this in a long line of items. She said GSR. I didn't even know what that is. I mean, it's a really, are we to believe that the jury is going to say, ooh, I wonder what GSR is? Besides that, as to Garland,
Well, let me ask you this. Her purpose as a witness to this jury is Mr. Byrd did it, right?
no, her testimony actually was, this is the evidence we gather from, because this is the crime scene witness.
Right, but the jury's sitting there taking the implication the state must be putting on this witness to prove that Mr. Byrd did it, right?
That the defendants, both defendants did.
So anything she may say in the context of her testimony comes with the inference that it proves he did it.
Yes, Your Honor. The report that they wanted to introduce, the FDLE report, says there was no gunshot residue as to any of the defendants. There was a big argument from the state that GSR are not reliable anymore, that they are not being done anymore, that there is no lab in Florida that will do this testing anymore. Therefore, the state was calling into question the reliability of that FDLE report.
But isn't that a matter for the jury to hear? I mean, that goes to the weight of the evidence, doesn't it?
Not in this case, Your Honor. I will tend to say that not in this case, because it's not the weight. Here, we were actually challenging the evidence that they no longer do gunshot residue testing in Florida. And therefore, that whether even this report was reliable, or because we needed the expert. Now in Florida, we need to list experts. Like Judge DeMorgian pointed out, you need to certify that this report was proper. What test did he do to conduct this test? Why? And here, the report was going to be that there was no gunshot residue. In this case, and again, even if it had been admitted or not admitted, it was harmless because there was one shot to the back of the victim. One shot. It wasn't that it was, and we were going under the principal theory. Either Colson, Byrd, or Samuel did the shooting. One shot. There was evidence that the gun was never recovered. However, the bullet, they testified that it was a 38 millimeter. and that the gun did not eject a casing or anything. Therefore, perhaps this gun would not have had gunshot residue.
Your
So,
time's up, ma'am. Thank you.
Your Honor, thank you.
4 quick points. I want to be as brief as possible starting now. Number 1, at the beginning of this trial, prior to the trial starting, the judge specifically suggested, she didn't order, but the judge specifically suggested to take the part out where it says they picked me up. In fact, I think the word she used might have been sanitize. Sanitize that meaning. So the judge at least had some sort of concern, although not ordering it, again, suggesting it. That's number 1. Number 2, I want to go back to your question, Judge DeMorgian, about the harmless error. Here's why it is not harmless error, and it's actually with the state's own wording in the closing argument. They told the jury the devil is in the details. That was what they used in the closing argument. It was the devil is in the details. Then they talked about the co-defendant statement versus Ebony Jackson. And admittedly, he said, well, both of them are lying. The problem again was they were unable to ascertain the veracity of that statement, the statement given by the co-defendant. The third issue I want to get into is the impeachment of the witness. The expert witness in the case, again, the Callaway case specifically addressed the expert witness's opinion onto the ability of a coerced confession. It did not go to the substance of the case or material fact in the case, but rather an actual confession.
On the court's suggestion to sanitize that statement, I'm assuming that I'm correct, that you would agree that that's not something the court, although it's well-intentioned, can't do. The court can't change the evidence to protect it from its own unfair prejudice, correct?
Correct. But with that said, the inference being that maybe the court had its own concerns by even saying that. Normally, under most circumstances, the court would have just said nothing, denied, go, do whatever you want. But in this case, there was something that alerted the court that made it want to suggest that they sanitize a statement. And the last point is the state, in their argument, talks about the presumptive test. In the reply brief that I filed, although it didn't deal with a presumptive test involving gunshot residue, it did go to those probation cases where they use those presumptive drug tests. Again, as I pointed out in my reply brief, although we all know probation has a lower standard for the finding, but the Hune case specifically allowed a presumptive test to be used in a probation hearing. So the idea of a presumptive test not being admissible or the idea of a presumptive test being admissible is not unheard of in this particular jurisdiction. With that said,
Thank you, counsel.
yes.
Let's give these lawyers a chance